and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. This week, we're talking about police officers and murder. Cases that should have gone to the Supreme Court of Canada, but didn't. James Forcillo, you've probably heard of him, was a police officer in Toronto. He was ultimately convicted of attempted murder after a trial for second-degree murder involving the case of a man who had pulled a knife on a Toronto streetcar. The streetcar had emptied, and there was a standoff with police officers and the knife-wielding man. Officer Forcillo shot the man 10 times in total, causing his death. At trial, the jury acquitted him of second-degree murder, but convicted him of attempted murder, which carried a mandatory minimum sentence of 5 years in prison. Officer Forcillo challenged the constitutionality of the mandatory minimum sentence, arguing that an earlier Supreme Court of Canada decision indicating that a 4-year mandatory minimum was not cruel and unusual punishment. In the circumstances, the Supreme Court of Canada was asked to revisit its earlier decision and consider whether a 5-year sentence was cruel and unusual punishment. The Supreme Court of Canada declined the opportunity to do so. And in my view, they should have taken this chance. Not only have increases in mandatory minimum sentences become such a significant issue in our justice system that cause more cases to go to trial, tie up more court time, and prevent the reasonable resolution of many files, but the Supreme Court of Canada also had the opportunity to comment on how increases in mandatory minimums since earlier decisions that those minimums are constitutionally valid play a role in the constitutional litigation under Section 12 of the Charter. There were majorly important issues here, particularly given the fact that the original case, decided in 2008, and the case involving Mr. Forcillo, had occurred over such a significant span of time. We now see an increase in society in attacks, terrorist-related attacks, involving lone wolf-type individuals, and police having to respond to that. And revisiting how the lone wolf terrorist attacks play a role in mandatory minimum sentencing, particularly for police officers who are responding to these issues, would have been something that better reflected the current state of society rather than that in 2008 at the time the Ferguson case was decided. The Supreme Court of Canada, I think, missed the opportunity to look at the entire context that was informing this case and informing Officer Forcillo's challenge of the circumstances of his sentencing. Unfortunately, we'll have to wait another day to see whether or not mandatory minimums for attempted murder are something that are vulnerable to constitutional challenge. And until that point, we're going to be stuck with the reasoning in the Ferguson case and a 5-year mandatory minimum.
You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't.
Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation, and I hope you like, subscribe, share with your friends.